Hello and welcome to the Herrington Carmichael Employment Law Update for December 2017. If you haven't spotted, Christmas has landed in the Herrington Carmichael office and I have 4 Christmas gifts of employment law to bring you in this month's update. So where do we start? We start with the Uber decision, which has got so much publicity in the last few months. We're now in a situation where Uber's latest appeal has been rejected, and once again it has been found that the individuals which Uber engages are in fact workers rather than self-employed. Uber have tried to leapfrog the Court of Appeal and have their case heard at the same time as Pimlico Plumbers in the Supreme Court, which has been rejected, but this is a continuing story in relation to the gig economy and whether individuals have employment rights. Watch it closely. If you have people working for you or engaged by you or on the boundaries of having worker rights, keep your eye on this and make sure you're doing the right thing. Next, the case of King and Sash Windows. This is a case from the European Court of Justice that relates to holiday and the taking of holiday where somebody is believed to be self-employed but actually has worker rights, where the company did not permit the individual the ability to take annual leave throughout the period of their engagement. In theory, the annual leave entitlement continues to roll on indefinitely throughout the period that they work for you. That resulted in Mr. King having a claim for £27,000. Not insubstantial. When you combine that with the growing pattern of cases in relation to worker status, this can be quite alarming where you have self-employed people. Keep a close eye on it. Next, the case of Graham and Agilitas IT Solutions. This relates to conversations between an employer and an employee pre-termination where everybody believed that they were without prejudice or protected. As part of the tribunal process, the respondent attempted to rely upon the discussion to demonstrate there had been performance issues and discussions with the individual. The Employment Appeal Tribunal has remitted it back to the Employment Tribunal on the basis to determine whether actually they were for a genuine in contemplation of litigation and designed under the protective characteristics of the Employment Rights Act. One to keep a close eye on, one to be careful with in terms of discussions with employees, and if you're looking to move people on in relation to settlement agreements, please just be careful about what language and what issues and information you give them. If you need help with that, let us know. Finally, the case of Baker and Abellio. This case relates to a search by the employer in relation to whether the employee had the right to work. The individual didn't provide adequate evidence of the right to work and was dismissed as a consequence. In this case, though, the individual did have the right to work, but was dismissed on an illegality ground. That was found by the Employment Appeal Tribunal to be unfair because actually it wasn't illegal employment because they had the right to work. The issue was that the checks hadn't been taking place properly. Now that potentially is some other substantial reason for dismissal, but once again this demonstrates that when an employer dismisses an employee they must absolutely get the right reason for dismissing. If you have any concerns on that, as always, please let us know. And the final thing for me to say now is on behalf of myself, the partners of Herrington Carmichael and all of our employees, we wish you a very Merry Christmas and an exceptionally successful 2018. Thank you.